Ladies and gentlemen of the jury.
Have you reached a verdict?
Welcome to the John and Jordan on Justice podcast, your weekly deep dive into personal injury and wrongful death law.
All rise.
Touching on everything torts, legal tech, trying cases to verdict, and the outlandish stories that come with them. And now, here are your hosts, John Fisher and Jordan Reed David.
Welcome back, everybody. Thank you for joining us today. This is a truly momentous occasion, not just for the podcast, because it's our first non-Fisher or David guest, but also it's a large deal for me personally, because today I have the pleasure of introducing the world, so to speak, to Harvey Sepler, who is many things to me and many things to many others, but among them, he is a mentor. He is an adjunct professor at the University of Miami School of Law in appellate advocacy, and he's a longtime appellate practitioner with immense experience on the criminal side and nearly just as much on the civil side. So without further ado, let's at least welcome aboard Harvey. How are you doing today?
I'm doing wonderfully. A pleasure to be here with you guys.
Yeah, Harvey, thanks for joining us.
Yeah, the pleasure is definitely all ours, and I think the listeners ultimately are going to be the ones to get the value here. I want you to introduce yourself, but before you do, I want to give the listeners a bit of background on you. So you spent the majority of your professional career in the Appellate Division of the Miami-Dade Public Defender's Office, which I would say for you, so you don't need to say for yourself because you're too humble, is among the nation's elite public defender officers to begin with for trial and appellate work. But the Appellate Division in particular, some of the people that have come through that office, yourself included, have really accomplished tremendous things on not just the local state stage, but even the national stage. You are one of the few who can claim that they have been to the United States Supreme Court on a criminal defense issue and prevailed, and not just prevailed, but unanimously 9-0 in the Rehnquist court. And a little bit of interesting trivia for everyone, at least for me, the opinion of that was JL, right? Florida versus JL,
yes.
A 2000 case, which the opinion was written and announced by none other than Justice Ruth Bader Ginsburg.
Right.
So pretty powerful, and I know we're going to delve into all of that, but maybe take a little time. I mean, you're born and now you're here. Fill in the gaps for the listeners. How did you get here? What do you do? Introduce yourself.
Great
for
question.
Everybody.
Before law school, I'm from down here, and before law school, I got a PhD. Got a master's and then a PhD, and then I did I got my doctorate at the University of Kansas, and then I did a postdoc fellowship at Vanderbilt, and then I worked for the U.S. Congress for just about a year. We were interning with them, and then all of a sudden the political winds changed, and everybody left Washington, including me. And so I came. My father was an attorney down here for 50 years, and over 50, and my cousin's a long-time attorney. So it was a natural thing for me to come down here and go to the University of Miami Law School, which I did do. I really like law school. A lot of people, they were anxious to get out and do things, and I absolutely appreciate that. But I was coming at it a little bit different because I was older.
Right.
I mean, I think I could have been conceivable. I could have been 10 years older than the students at the law school. I really liked it. I mean, there were a lot of things that are kind of crazy about law school, but in general, I did. When I finished there, I clerked for 2 years at the 3rd DCA for Judge Hubbard, who was the former chief judge there. Of course, but Judge Schwartz had sort of occupied that seat for a long, long time. So I spent 2 years down there. And then, and I was pretty good friends with Judge Hubbard, and he basically said, it's time. You don't want to be typecast. You need to kind of go out there and start doing things.
Right.
And he had been the former public defender of Miami-Dade, and so it was. And I knew people in the office and in the appellate division, so it was a natural thing for me to take the transition to doing there. And I really liked it, as Jordan, as you just said, it was a wonderful office in the division. These folks are just incredibly bright, and something that I never had to deal with that you two and your listeners have to deal with is overhead,
right,
and scheduling and things like that. These are, they're the necessary part of practice for most of us. I didn't have to deal with that, and that freed me up to do what I felt was pure law. Issues would come in, we would work on it. Sometimes we work on it together. The only thing about the office that was difficult is, understandably so, it's very busy.
Yeah.
You know, we had a caseload that was enormous. When I started with the office, we had 80, 90, as I recall, or so appeals that had been dismissed by the 3rd District because they weren't prosecuted. And I I did a seminar, which is similar to what, John, you and I were talking about a few moments ago. I did a seminar for the Dade County Bar Association on appellate practice. And I had Judge Schwartz, and I had Judges Pearson and Hubbard, and I had Ted. Well, these names aren't going to necessarily mean a lot to you, but they were our finest. Bruce Rogo, Roy Black. I mean, it was just wonderful. The people that I had compiled for this seminar. It was an all-day thing. And the hook of the seminar is that you had the opportunity to take an appeal from the public defender's office. You weren't going to be paid, but it was your opportunity to work with some of the attorneys in the PD's office. They were our cases. We had responsibility for them, but you would do the work and you would do the oral argument and you would sign the brief.
Really? So you were allowing private attorneys essentially
Right. They were essentially special assistant public defenders. At that time, we didn't really have that. And the beauty of it is,
so to speak.
yeah. And the beauty is we got rid of the entire backlog just because of that seminar. And that was a really nice thing.
Now, how many years I know you retired from that office, but how many years was your tenure?
I was there for about 30 with the state with the DCA. It'd be like 30 some years and 31 years of state practice. And in that time, plus I now do private appellate work. Do a lot of civil now because it's different and I enjoy it very much. I've done something like 1,400, 1,500 appeals to all levels of court, and it's great. So I really enjoyed this kind of work. I have a tremendous amount of admiration for attorneys who can do trial work or office negotiation practice. This was the best fit for me.
Sure. You know, it's interesting you say that because you look at us like we have respect and admiration for us. I'm the alternative. I look at you guys as one, I could never be an appellate lawyer to the level that you guys are, but I look at it with such high respect, the quality of writing, the advocacy, the approach, how you handle the appeals. Like, it is definitely for certain people. I'm not one of those. So I look at you guys and Jordan as well because he's,
He can do both.
Right. He can do both. And I think he excels at the appellate level because he's gotten some good favorable rulings on appeals for our practice, new trials, repeatedly, injunctive relief. And so, for me, you guys are probably, I would say, the most important part because you guys correct errors and wrongs at the trial level for us. It could be, or to uphold the verdict.
Well, I appreciate you lumping me into the group of Harvey, but if anything, I'm living in his shadow and hoping one day to fill his shoes, because all you've accomplished in your career, I'd be proud to look back on my own and say I've done half that when it's all said and done. But I wanted to pivot a little bit because I feel like I'm one of the few out there in the South Florida area who's had the privilege of working alongside you, or at least having an opportunity to be an apprentice of sorts and see how you work, given that you were kind enough to let me intern for you in the Appellate Division of the Miami-Dade PD's office for a while. And also I was your student at the University of Miami School of Law. I took your appellate advocacy class, and you were my direct coach when I was part of that moot court board. So I've seen how you work through problems and solve them in written and oral form. And I, to this day, constantly hearken back to words of advice and wisdom you've given me. So let's kind of shed some light for the listeners, because I think a lot of the trial lawyers out there have this image of an appellate practitioner. He or she's off in some distant tower or dungeon, as it were, and they're just trolling through issues and they don't want to be bothered with people. But I will share, from working with you and seeing how others like, Stephen Weinbaum, and others there. I mean, it's a very collegial environment, even in the Appellate Division. And you guys used to openly embrace the trial lawyers coming in the first instance before the issue had crystallized, so to speak. Yes. And they would solicit your input and feedback to help shape issues. And maybe you can shed some light on, a long career of helping trial lawyers avoid landmines, so to speak.
Well, as you know, Jordan, and by the way, let me just take a moment here because you're kind enough to say some very nice things about me. I have had the chance of working with Jordan for a number of years, and it's been an absolute pleasure. what we did in the public defender's office in the Appellate Division, which again it was a marvelous experience for me, is we had what's called the boss of the week, and that was the attorney in the division. It would change each week. That would basically be on call for any trial attorneys that had questions about things, or anyone from the public, or any attorneys. You could call our office and you could speak to the boss of the week, and then the boss would then go around and find attorneys who have worked in that area. In addition to that, if I got an appeal, the starting point, as you said, Jordan, is I always contacted the trial attorney, because you guys know best the case, and it's got to start there.
Right.
We used to, and I don't know if they still do it, but we used to have what was called a trial information sheet, which would go to the trial attorney, and that's how we would even find out about your case. And you would tell us what the issues that you thought needed to be addressed. Now, of course, you didn't prevail. I don't want to say, obviously not you, but generally, or else it wouldn't be coming to us. And so very often, there's the emotional side of things that in some way you or the client was wronged about a ruling that the trial court made. And so we had to kind of back off a little bit and look at this thing in a more objective way.
Right.
I've always thought of appellate attorneys, not that we're anything special, we're kind of like surgeons. You are the doctor for the client, for the patient. You take care of him or her. You know all these. And if a problem arises that you need addressed, you might call in a surgeon for the limited and express purpose of doing whatever the surgery is. And once the surgery is over, the patient goes back to your care. And that's kind of at least the way we would think of it. It's not always that way, because as Jordan, as you said, there is an absolutely definite role that appellate attorneys can play to work alongside trial attorneys, but it's your case.
Right.
So ultimately, at least the way I look at it, you make the call, but we can be there to help you make the call that's going to end up working best for the case. And so,
Yeah, and I think in private practice, especially on the civil side of it now, having done it for a few years, I think trial lawyers refer to that role as like trial support.
yes,
And there's a lot of appellate specialists out there who promote their services, not just for plenary appeal or, petitions for writs, but in a trial support capacity. And I think what I would say to the listeners out there, if you're a trial lawyer who's a part of a small or even a solo firm, whether it's ego or fear or uncertainty of how that kind of collaborative relationship would work, I would encourage everyone out there, if you don't have someone like a Harvey Sepler on speed dial, I think you're doing yourself as a trial lawyer an injustice first, and that there's definitely a trickle-down risk to your clients, because we're not the all-knowing, seeing eye. When we're in the trenches, very often as trial lawyers, we're bothered with discovery requests, or our minds are wandering about a potential evidentiary issue at trial that really is, not going to come up on appeal, but in the moment, for when you're litigating a motion to eliminate or something, it's important to you. But your mind is not always thinking 2, 3, 4 steps ahead. And an appellate specialist like Harvey or someone similar to him, there's plenty of them out there in the state, they're a tremendous resource to come in and kind of give a different perspective and help maybe shape an overall strategy so that you're protecting your client's back end in the event things don't go your way, because trials can be crapshoots no matter how good or bad.
I used to, when I'd go down sometimes to the trial courts, and I would watch trial attorneys. It's really amazing what you all do. It really is, because you've not only got your all the work that you put in beforehand, and you've got witness examination that's coming up, and you've got evidence, but you also have to remember how to preserve the record.
Correct.
I mean, it's amazing to me that trial lawyers, when they're good, can successfully do that. We don't have that problem, but we inherit the record that as it comes to us. So that means if in some way it wasn't preserved the way it should have been, we have no option but to go with it the way it is. I've had, I don't know if I've mentioned it to Jordan, but I've recently had a couple of civil cases, fascinating issues. Really, I thought it was just wonderful. But because the complaint was drafted with sufficient facts that needed to be in there. Ultimately, I mean, I tried my best. You can beat your, the drum all you want, but ultimately it may come down to that. I've had two instances. One of them having to do with an arbitration in a wrongful death case. The other one had to do with a negligence case, a liability of somebody who lived with this woman, and the woman ended up committing suicide. And the question is whether he had responsibility for that. And it's a great issue, but ultimately it came down to how it was pled.
Yeah, and that kind of stuff's matter. I mean, we have been, myself and Jordan, on the receiving end of a non-preserved issue. Right. We had it was a jury trial, one of our first early trials. And the benefit is Jordan, I have him there. He does have that appellate experience, but preservation is something that's not really taught to trial lawyers to how to do it, extensively. That's why postgraduate education from other lawyers and speaking to them is important. For an example, jury selection, right? This is, you always see this is a bad issue, but it wasn't preserved, right? If you've got your panel and then you request additional peremptories because a cause challenge was improperly denied and the court keeps giving them to you until you get a denial from a peremptory request, I don't think there's any preservation of any issues. Because,
well, John, what's really funny? You bring up jury selection. The very first memory that I can recall interning in the Appellate Division for Harvey, I'm sitting through and he said, look, here's these couple of cases we're going to have to brief, familiarize yourself with the record. So they're post-trial, plenary appeals. So what do? I'm jumping right in. Page 1, volume 1, I'm reading jury selection, starting with the judge's voir dire. And I think somebody else came in and said, what the hell are you doing? Skip to the page where they impanel the jury and see what the trial lawyer said. Because if the trial lawyer impaneled the jury without renewing or saying some carve-out language, subject to and not with, waiving these prior objections we tend to the panel, there's nothing that's going to be preserved, and you're reading for naught. Now, at the time, obviously, I'm reading for education, and that's just one example where it's like, even though I was a law student, I know many trial lawyers out there now that don't have the benefit of someone showing them that. That stayed with me for my career.
Right.
John and I have since gone on in private civil practice. We won a new trial in the 4th DCA, and part of the issue was preservation, but we won because we used language that Harvey taught me way back when. But anyway, Harvey, I think your point is a valid one, which is preservation alone can often be the deciding factor, so to speak, on whether a really juicy, meritorious issue on the substance even gets its day in court. Because appellate courts, and maybe you could shed some light because you know appellate judges, you clerked for them, and you've done this now for many years. Maybe you can talk a little bit on how important it is knowing that these judges are busy, their dockets are also full, and while they want to do justice, they're not out there to right every wrong. They're out there to make sure the law gets followed properly, and part of that law is preservation.
Well, let me just backtrack just for 1 second because I want to just go back to what I was saying before about those couple of cases. I don't want to malign the attorneys.
Right.
A lot of it, as you guys know, and the people that listen to you, you have to you structure things according to the cause of action and the elements of it. And a lot of times the facts aren't known or knowable to you at the time that you have to file the complaint. So please understand, when I was referring to this, I wasn't trying to comment that in some way these folks didn't do their job. They did.
Well, but it happens. I mean,
it happens.
Jordan, we had a complaint that we pled it as a negligent security and not a premises liability, and a trial verdict got reversed on appeal by Judge Rothenberg for that issue. And it's like you didn't really think how the facts would play out, so it happens.
Which is another reason, taking it back to what Jordan was saying earlier, sometimes it's good to have somebody else in the background that can kind of give you another look to it. Now, in terms of the preservation, John, you and I were talking about this the other day. I mean, if you think about why there is that whole concern about preservation of error, it's really the way the court system was worked. Article 5, it's the way that the court system is structured. Trial courts are courts of fact. They are. That's where you have the witnesses. That's where you have the evidence. Appellate courts really are courts of law, and they only look, by and large, at issues of law that came up in the course of trial. Now, appellate courts are also set up. They are not courts of law. They're not supposed to be retrial. They are essentially an appellate court is essentially like sitting over the shoulders of a trial attorney, of a trial judge, and they ask, given the facts of the case, given what was argued, the complaint and what the parties argued, and the law, did the trial judge make a legally correct decision? But in order to get there, you have to give the trial judge an opportunity to make a legally correct decision. So if, as a trial attorney, if you don't object to something, and if your objection is not contemporaneous and it's not said with specificity, you're really not giving the trial judge an opportunity to make a legally correct decision.
Right. So
that's why there's this whole preservation of error concern. So what does that say to you guys? That means when you object, you've got to whatever extent you can, put one foot in the trial judge's position. Did I make the objection timely so that the trial judge could correct the error and it's not going to be a problem down the road that would either affect the trial or that would involve the appellate court getting into something that they might not have had to expend their resources? So did you make that objection timely enough? Were you specific on what ground you wanted me to rule on as a trial judge? If it's just, well, it's not admissible, well, that doesn't tell me anything. How can I rule on that unless you're very specific? And you need to be. And what was the relief that you asked for?
Right. Can I interrupt you because I want you to explain this? The relief you ask for. I know every trial lawyer out there right now who's listening, if they're being honest with themselves, has had that moment in a trial where something objectionable took place, you contemporaneously objected, and then you sat there and you thought to yourself in that brief moment, I think I need to move for a mistrial to properly preserve this or give myself the best chance of an appellate review later. And then you have that decision, like, do I even really want a mistrial? Cost benefit, is it worth it? I know I've had that come up. I feel like every other trial I've ever had. Can you explain a little bit more the significance? I mean, it's not that every objection needs to be followed up with a motion for mistrial, but that there are occasions where just objecting might not be sufficient because you didn't then take the additional step, whether it's rejecting some type of curative that was proposed or asking for a mistrial, whatever.
Well, think about what it is that you're asking the trial court to do. Suppose, for example, it's the admission of evidence, and the evidence ought not to come in. So on one sense, you're saying, well, you shouldn't admit that evidence. On the other hand, suppose it was a comment by a closing argument comment, and you want to say, well, it's really prejudiced our case. The relief you ask for is very important because if you ask for a motion for mistrial and that's denied, then the appellate issue is the denial of the mistrial. It's not necessarily letting the comment in. It's depriving you of the relief that you thought was appropriate. If you said, well, the argument of counsel was improper, and that was it, and the court said, opposing counsel, don't do that again, is that sufficient relief? It certainly is cured in some way. It's stopped it from happening again. But as I say, it's hard, and I believe me, I completely appreciate what you guys go through. But you have to have at least 1 foot, to whatever extent you can, in the trial judge's position, so that the judge can make a legally correct ruling.
Yeah, and that's happened to me, and I share this with you, and kind of what you told me is that, like, from an appellate standpoint, you got to give the trial court an opportunity to get it right first.
Yes.
Right. And so when you make a timely objection, you lay it all out for them, give them an opportunity to do it right, because that's what appellate courts want. They don't want to be the ones having to come in and second guess the trial court.
Correct. That
they didn't get that opportunity. But I struggle with this, and I know with Jordan, we've been trying cases early in our careers that, the motion for mistrial, or do I request a curative? Is the curative enough? If the court says, I'll give you a curative, and then I say, well, I don't want the curative because I think it's too prejudicial, I want a mistrial. And then, well, so now you're rejecting a curative. Are you now rejecting relief from the court? And it's like, it creates these issues that I sometimes don't even know the answer to. I look at it like I move for mistrial on everything.
It's not an easy call. I mean, if the judge gives you a curative,
right,
and even if it's not what you want, you think, well, I'm better off with that than not.
Right.
And you say, okay, then you've waived the issue.
Yeah, and back to Jordan's point about sometimes you want to let things go. So we were just in the case that we tried, we had very specific motions in limine. The judge was on top of it, and the comment came out from the witness that was not supposed to come out. Judge looks at us. She knows it's a violation of that motion in limine, but myself and Jordan collectively didn't make a deal about it because we knew that it in the grand scheme of how trial was going, we were just going to bring attention to it, right?
And we didn't want a mistrial there. With trial overall in the aggregate was going good. We wanted that verdict.
Right. And so we allowed that to pass. And what I have done, and some judges go for this, some don't. When you move for mistrial, you can ask the trial court and say, I want to move for mistrial. However, I want you to defer ruling on this mistrial until such time as the jury verdict comes back to see if the jury can correct the error itself. Right? Some judges will do that. Other judges will not.
I have some that have looked at me holding in their mind's eye, at least the proverbial gavel. You want a mistrial? You got it. Just say the words. Then you gulp.
Right.
Well, never mind.
Yeah. And
we don't.
We had a trial like that where we had, essentially it's a judge that I work with. We have a great working relationship. I didn't even want to move for mistrial. Jordan said he was a spectator. He wasn't trying the case with me. He says, you have to. It's for the client. It's not about what relationship you think you make. Because he basically called me disorganized in front of the jury. He was like, let's take a break so maybe, you can go and get organized. Right? So it gives the suggestion to the jury that I'm a disorganized lawyer and coming from the robe. That could be prejudicial, right? So he comes back in. I finally, Jordan convinced me I move for mistrial. And then I say, he says, let's get through it. We'll deal with that. He allows me to finish cross-examination of the defense's corporate representative, and it goes amazing. Like the best cross that it could have happened in this case. Then when
the judge took his foot off the gas. Let's be real. He was tailgating you, to use a crude analogy. He was tailgating you to see any misstep you were going to make during cross, and every single time you were doing it before the break, he was right there to kind of chastise you in front of the jury, and that has a devastating effect, I think, in the aggregate. And then after you, on that recess, basically moved for a mistrial and said it's improper, you have tarnished my image in front of this jury, he then, mum was the word, unless something egregious came up, and it allowed you to finish delivering what was ultimately the most impactful cross-examination in that trial, which resulted in a multi-million-dollar verdict. So.
Right, and so what happened was I gave the judge, I said, now let's go back. He said, let's go back to the motion and for mistrial. And I said, can we wait to see? And he says, no, I'm going to rule right now if you want me to. And so I said, can I have an opportunity to confer with my client? He was like, that's fine. So I talked to the client, we talked to Jordan, and we collectively decided to withdraw the motion. So there's ways that that sometimes you think an issue may be bad, that sometimes it's better to try to get relief, even if it's a curative or an admonition or something like, don't do that, disregard that. And jurors are smart, but sometimes cat out of the bag, you can't fix it. So
let me do this if I can, because I want to switch gears a little bit, and I don't want to lose sight of the fact that it's important to me that we talk about JL in a pretty large degree. But before we get there, I want to stay in the civil realm just for a bit and talk a little bit about earlier stage issues that arise that I think trial lawyers sometimes have a bad habit of saying, well, I can't take an immediate appeal. And, by the time we try this case post-judgment, take it up on plenary review, who's going to care? Like maybe a discovery dispute, for example, is a clear example of this.
Right.
Harvey, maybe you can explain to the trial lawyers out there, yes, not every adverse ruling on a discovery motion or something warrants immediate interlocutory review. However, there are occasions, especially when you're representing human beings in a personal injury case, like, for example, let's say the Florida constitutional right to privacy is a basis of a legal objection, and the trial court, let's say you're using that as a basis to say, judge, no, the defense can't have this discovery. And the judge just overrules it, grants a motion to compel for the defense and says you got 10 days to give it. No attempt to put any kind of intermediary stopgap, whether it's in camera review or anything. So I guess what I'm really saying is, in a general sense, are there some situations early on in civil litigation where some trial order things can be taken up on interlocutory review?
Well, you would probably, if it's a discovery, you'd probably want to go by certiorari.
Right.
So the cat out of the bag type of thing. And that the test for certiorari is different than on appeal. It's a 3-part test for cert. It's a departure from the essential requirements of law, material injury, and no relief by way of appeal after the case is over. So it's a different test that you would use for cert than the non-final appeal under 9130. It's different. I would imagine that there are times when it's significant enough for you to want to take cert early on, because you also don't want to waive it. Right. And you also don't want the discovery to happen or not happen when it should. That's why I say, you all know your case. You know what's significant. That's why I was saying, John, earlier when you were talking about, John, about that you and Jordan make strategic decisions. And that's really the way it should be. It should be, you know your case better than anyone's going to know it. Depending on the strategic decisions, it may affect whether a relief is available to you or not. In terms of discovery, I suppose that if it's a significant one, you could file for a cert petition in the middle to see. At least at that point, you've also preserved any objections you've got to it.
Some people out there who are doing the trial stuff exclusively, they might have the false impression that I have to wait until after trial to appeal anything. And, generally, of course, that's going to be the rule. But there are exceptions to that, and sometimes, not always, but sometimes it's appropriate to do that, whether it is to protect your client's right to privacy or maybe something more meaningful, which is like, there's a trending issue that hasn't really gone the way of the plaintiff's bar or the defense bar, whichever side you're on, and you finally have a good vehicle for it. How are you going to know unless you have someone like Harvey or someone else with similar appellate experience who you can call on and ask, because I guess the flip side of any appellate token is sometimes it's strategically beneficial to not take up a quote unquote bad case and risk making, gray law even worse.
Yes.
Right. So there's definitely an issue of selection there.
But let me just go back to one thing. If it's a discovery issue, and of course you know this already, you're going to go to the appellate rules and see whether the rules allow you to take a non-final appeal. And I don't think that's going to be the case with discovery violations. So, you're talking about cert, and it probably wouldn't. They probably wouldn't render a decision. I don't know that that's the case.
It's rare. We've done it on a handful of occasions over the years, and I think
So it wouldn't necessarily have any dispositive effect on later cases. But you know what? You're absolutely right too. If the case is marginal, or if the issue is marginal, you're in it for the long haul.
Right.
It goes beyond your case, and so you need to pick and choose what are the best cases to take up. You obviously want to do the best for your client, but there may be times where the law is not entirely clear, and this isn't the case to bring it to the court to make it clear, because the facts of this case make a good decision less likely.
Can I ask you guys this question? Because you guys are both appellate lawyers. What I tend to see as a trial lawyer is I have a very visceral reaction to what happened in a trial, and then you get the transcript, and on a cold transcript, it doesn't come out as bad or as egregious as it's felt to me at trial. Does that factor in any way? I mean, you've talked to the appellate judges. I mean, does that, when they're reading a cold transcript, they don't have the benefit of being there, does that factor away in any type of your approach to handling an appeal? Or
I'm going to give an example, but I want Harvey to answer.
No,
we just recently, John, one of our cases in front of the 3rd District, we won, but during oral argument, then Chief Judge Emis said, well, Mr. David, during your argument to me today, you're emphasizing certain words like it was said like this at trial. But how do I know that from the transcript? He called me out on that, and I thought it was a fair criticism. I wasn't doing something intentionally. I was at trial. I knew that's how it was emphasized. But this goes to John's point. So, Harvey, maybe you can explain.
Well, that's actually it's a great question. It's a great question, and the answer, of course, it's going to be interesting to see how Zoom trials affect that whole scenario, because now they can actually see. But it's a legal error, and the court uses a reasonable person standard to see what the effect would be, and that's why when you're at trial and opposing counsel makes an argument and closing argument that's improper, you need to say not only I object to it, but here's why, and here's what it can do to the jury. Here's what a reasonable jury, how they would likely react to the argument that you just made. That helps the appellate court.
Okay.
Because now they can see, well, obviously this has the potential of affecting how the jury would feel. I mean, I'm doing an appeal right now, commercial appeal, and without getting into the specifics of it, the clients, are they've been really harmed by this action, and they've been wanting to appeal this. They are wanting to, and they've been wanting to describe it in a certain way, but I have to kind of keep myself back from the emotion of it and just look at it as a purely legal issue. That's why the analogy to a surgeon coming in is so important, because they're coming in no matter what position the patient is in terms of what he or her background would be, or anything else that might be going on with that patient. They're coming in for a specific purpose, and it's a very discrete purpose. And they know that once I resolve that purpose, that patient goes back. And it's the same way here, unless, of course, you're talking about having an appellate attorney that you consult all the way along. We come in to help you resolve a specific purpose, and that's all.
Yeah.
Yeah, and oftentimes I've learned, I say the hard way because I don't know any other way to describe it, but you fall flat and you get yourself up and you do better the next time. Fiery or emotionally charged language has a place, and it's not in an appellate brief or oral argument.
I agree.
Very often.
I know that when I clerked at the court, we would sometimes go down and watch the oral arguments. And there were trial attorneys, again, I'm sure they were excellent trial attorneys, but they would argue to the court as if they were arguing to a jury. But of course, appellate courts aren't courts of fact.
Right.
And the equities has a different meaning on appellate as they do in trial. And appellate judges, I don't think they particularly like that.
Yeah.
They don't like. Nor, on the other hand, trial judges, when you argue to trial judges, they're interested in the law, but they are more, involved in the case. And so you can make a more impassioned plea to them. Ultimately, their decision is going to be on the law.
Right.
Hopefully.
Yeah.
Now, I know most trial lawyers out there, I think I speak for most trial lawyers, when I say oral advocacy is what they emphasize most in terms of skill development and all that. But you have the obligation, I would say the responsibility as an appellate lawyer to be compelling in oral and written form. And as someone who's seen how you draft and so detail oriented, and you have a very good ability, one that people in CLEs talk about just generally is, you should try and boil things down into plain English, make an issue simple so that anyone can understand your position. You do that better than anyone else I've ever read, and I've read some really interesting briefs by really accomplished practitioners. And I continue at this stage of my career to try and do what you do and have taught and still teach law students, which is on the written side of things. There is no issue so complex that you can't find a way to either analogize it to something more simple or find better language that can boil it down so it's easier to understand. And maybe you can talk a little bit about persuasiveness through a written brief or motion. If it gets too clunky or cluttered up with complexities, sometimes it loses its efficacy.
Well, I absolutely agree with you. I mean, when I remember on the third, they used to have there was a judge, Joe Nesbitt, who was a great appellate judge. I really liked him a lot. And he used to say, well, oral argument is like you talking to your next door neighbor over the fence that divides your property. And if you can't, if after that conversation, he has no idea what you just said, you haven't really been persuaded him as to anything. I'm sure that in patent cases or some of these very technical cases, it's difficult to understand. I got it. Bankruptcy cases or other things, but generally the cases that they're very simple. They really it can. My dad, who was a longtime attorney, wonderful, not a litigator but a wonderful lawyer, he used to say, well, when you're dealing with these cases, close the book every once in a while and walk away. Go for a walk, go to the gym, do whatever you need to do. And I tell my students the same thing. Just close it up for just a little while. Go somewhere else and just think, what makes this so important? Why is this such an important issue? How will it affect not only this client but others in the client's position. If you can't be really simple about this, you may not understand it well enough. I mean, I was sometimes you get so engrossed in things and so emotionally charged into the things that you're working on that it's hard to extricate yourself.
I once heard you say during a moot court practice round to me, or maybe my teammate, but it was to us, and it was something to the effect of, everyone in the room knows why you're passionate about this position. You're the advocate, but why should I care, as the judge? And I think this applies equally at the trial and appellate court stages. At the end of the day, you have to know your audience. And if you're writing briefs or delivering oral arguments to embarrass the other side or, stick needles in the other side and humiliate them, you may get personal kicks out of it, but you're not doing anything to persuade the bench. They're there for an entirely different reason. And so, I don't know, maybe you can talk a little bit about that, about, writing or speaking to the audience that you want, not the audience that you think cares.
When I write, like when I was working on one of the JL briefs, the one that went to the Florida Supreme Court, the perspective is different when it went to the U.S., but in the Florida Supreme Court, I had organized my stuff where I broke it down, the argument broke it down into subsections, sections and subsections. And each subsection or each section, I always concluded. I know it sounds very simplistic, and I understand that I'm sort of taking it out of context, but you look at it like you are taking your reader or your listener or the juror or whoever by the hand, and you are walking them through very gingerly through the case. And each stumbling block along the way, you make sure that you've convinced them as to that one, so that when you get to the next one and you convince them on that one, and the next one, ultimately, when they reach the end, they oh, yeah, of course, that's the answer. Because when you tell somebody what the answer is, a lot of times the hair goes up on the back of their neck, and they're thinking, well, can I really believe this person? They're an advocate for this or that. I'm not sure. Maybe I should listen to ideally, you want them arriving at the same conclusion you did, and that you want them to think that they got there on their own.
Right. So you guys are essentially performing Inception. You want to supplant the idea and allow it to grow itself.
People are committed to the position that they've arrived at after thoughtful or whatever they do.
Right.
And they've reached it, and they're committed to that. They don't really want to shake that. I mean, you can try to convince them to shake it. You don't want that. You want them getting to where you ultimately are going to be, and you want them to think that they got there on their own.
That's actually interesting, because I think you're right. I mean, I think that, human nature, the strongest opinions that you can have are ones you felt that you developed yourself.
Right.
And so if, that's kind of like when you guys, and look, I'm not an appellate lawyer. My only appellate argument was from a county court into circuit court, sitting in its appellate capacity when I was a solo they vacated a default judgment, the trial court, and I went up and got it put in place on appeal.
Right. Cool.
Yeah. I mean, but there was no one on the other side. They set it for oral arguments 3 years after I filed the brief, that kind of thing. Yeah. So you guys, I mean, that's why you lay out the roadmap. You ultimately know this is what I think the court should do. Let me show you how you get there. And then you give them that law, those facts, those brief facts that are relevant to the appeal, and let them make that determination. So I think the same is true kind of of a trial from a jury. If you say, this is what you need to do and this is your opinion, but no, you give them the facts and evidence to allow them to come to that conclusion on their own of they were wrong, they were harmed, the defendant's responsible, and they're entitled to compensation.
Yeah,
so,
I mean, if you think about it, when you stand up there to the jury, they don't know you.
Right.
Obviously, they're forming a quick impression of you, but they don't know you, and they don't know whether they should trust you or not. Opposing counsel gets up and gives a characterization of the facts that are entirely different than yours. They don't know you. So to the extent that they can see you as one of them, that you are empathetic not only to your client, but that you are one of them. You're not really that much different than the other jurors. Then they're going to trust you a little bit more. And so I think a lot of times people write, like if they write a brief or whatever, that it just bombards people, bombards you. This is what the law is. This was terrible. This has got, your reader isn't necessarily going to be so receptive to it.
Right.
You've got to take them by the hand, whether it's a brief or oral, and walk them through very gingerly so that they get to where you ultimately want them to be. And I went to when I was at the early in the PDs, which what I thought was the best CLE I've ever been to. It was at Florida State, and it was an appellate one. And it was 2 days. The first day was about writing. The whole thing was just about writing. And the second day was giving an oral argument. The first day, they had no lawyer. They had no judges. They had no lawyers presenting. None of this they had lawyers. There were no attorneys that presented in either one of those 2 days. The first day about writing were all newspaper reporters and editors. And basically what they said is, we have a limited amount of time to reach our audience. You look at a newspaper, you're going to know in the first few paragraphs, or whether it's on screen these days, but you're going to know in the first few paragraphs whether this is something you want to get in, you want to read more about. And if the writer doesn't grab you in the first few paragraphs, you're gone. You're on to somewhere else. Plus, if what you write is too cumbersome, is too difficult for me to get through, I'm going to stop reading what you've done and I'm going to read what the other side says. Or I'm going to give it to a law clerk to read. I just don't have the time to go through all this stuff. And then you've lost your audience. Your audience is the judge.
Right.
So if what you write is too thick, same thing to you. You guys do trial. You do memos. You do motions. If the stuff that you've got is not interesting, if it's not easy for me to understand what you've written, if it's too cumbersome, too long, then I'm going to stop. You got a certain amount of time of my attention. So, and the same thing with oral argument. The second day was oral argument. No lawyers. It was all actors, acting coaches. And it was great in terms of how you want to stand, how you want to. And you've got it, John, you were saying earlier with working with the trial advocacy program. It's so valuable to learn from people who do this as a line of work. And so in your point, Jordan, I mean, with the students, and I've been fortunate enough to work with a lot of students. I've been teaching appellate advocacy for 25 years, something like that, all year long. And I just like you, Jordan, I've had some opportunities to work with some really wonderful attorneys or attorneys to be. And what I try to impart to them is exactly the same thing that we're talking about. A number of years ago, the Daily Business Review, this was a while back now, but the Daily Business Review had done a lead article on what are the best qualities of attorneys when they come out of law school. What do we most look for when we're hiring new lawyers? And what are the things that they are best at and least equipped at doing by and large with the attorneys that come out of law school? And the number one hands down thing was the ability to write. We're not talking about appellate now. I'm not talking about appellate. Just across the board, it was the number one thing that law firms look for when they hire attorneys at a law school, and it is the number one weakness that they thought that in brand new attorneys have a problem with, is the ability to write. Writing is absolutely critical. You do it every day in what you do. All the attorneys that are working with you, you guys do it every day. And sometimes people don't give that adequate thought or appreciation to how what they write is actually going to affect their reader, the person that they're most trying to reach, because you're so darn busy.
Right.
Understandably so. So at least.
Well, I don't mean to be cheeky by any stretch, but I mean, on the appellate side, it's called a brief for a reason. And you probably heard 10,000 people say something similar, which is brevity matters. It's if nothing else, on a base human instinctual level, I think it's a show of respect to the reader, your audience, the judge.
I 100% agree with you. I mean, I can tell you the appellate rules, not that I'm a better appellate attorney than anybody else, but I will just tell you, the appellate rules give you 50 pages for an initial brief. It's rare that my initial briefs are more than 20 to 25. When I was clerking at the court, there was an attorney who's long since passed, but they talk about him still. His name was Sam Daniels. And I remember, and this he had passed away a lot longer than what I'm going to tell you. Even though he had passed away maybe 10 years before that, these judges still talked about him. They still talked about his briefs as being short and right to what it is that had to be done. So you're absolutely right. I mean, brevity is a very big deal. Put yourself in the judge's position. You got 25 cases that are ready to be read. You got 100 briefs that you have to go through. If you're going to read a brief of mine and it's not easy, it's not plain language, it's not interesting, it's too long, it's all over the place, you're going to put it down. You just don't have time. So you're going to give it to your law clerk. You say, "What the hell is he talking about?" or they're going to say, "Well, let's see what the other side has to say."
So then, from the appellate standpoint, I mean, I mean, look, they both serve important fundamental, I guess, aspects of an appellate argument is the brief, the writing, and then the oral. But since that's your first impression, is the brief writing really more important than the oral aspect of it?
Yes. It's like I say about the brief, if I'm holding a piece of paper. When you hand in a brief, just like when you hand in a motion or a memo, you are telling the court, this is the best that I can do. This speaks for me. I've taken all the time that's necessary to compile something that is well-researched, well argued, is consistent with the law. There are no mistakes here. That's what you're saying when you give them the brief. What you are saying is, you can take my brief and you can read it anywhere, on an airplane. I don't care where you are. Everything you need to know about this case or about this issue is in this brief.
Right
it
here.
speaks for me. So if you hand in something that's got lots of mistakes or is too whatever, you're saying something about you.
Or even too one-sided, right? Like you get slick and, leave out a case that's adverse to your position, but it's on point.
Well, it's like cases come and go.
Right.
Your reputation is going to stay with you for your whole career.
Yeah.
And you should never scrimp on your reputation.
Well, I think Jordan had a big appellate issue regarding it was like the assignment or whether an arbitration provision ran with the land for a homeowner it runs with the land to a subsequent purchaser. I think it's up on Supreme Court review, but this was a renter. So Jordan they moved to compel arbitration. We were against it. He actually said, this is the seminal case right now that's actually up on appeal. They never even cited it. The other side moving to compel arbitration. He says this is the law. They said it can run with the land with particular provisions to a subsequent purchaser. But here's the distinction because it's a tenant, right? And he had some constitutional arguments and all these kind of things, but gave them the case that the other side never even cited. And then cited a rule that was actually not in effect at the time of the assignment, was actually a later rule, but then tried to use it and apply it retroactively. So they ended up, trial court went with Jordan, and at first, which is interesting about it is because it's in a different county, and we kind of got hometowned when we started out. But now Jordan has demonstrated this is the law, it's correct. He gave it to them, properly, cited all the cases, even ones against us. Trial court went with us and was affirmed on appeal by the second DCA, who was the one who decided that decision, saying it did run with the land for a subsequent purchaser. So, that what you're
Can't run
referencing-
from the fight, I think, is the
Right.
lesson, because and it's about candor to the court. It's about your credibility, reputation, like Harvey said. At the end of the day, though, it's also about being honest with yourself about, do I have a legitimate position or not? Because if the other side, through mistake, oversight, or mishap, whatever, they serve you up a softball, and you can knock it out of the park, but you really know that the law is throwing you a curveball or a knuckleball, you still need to be able to hit that out of the park. And I think you just got to tell the court, I'll hit both pitches, and here's why I'm not running from it. But
and the court is more likely to trust you, not only in this case, but in future cases. If they get wind of the fact that you're playing a little bit fast and loose with the facts, or you're not really signing things, or you're misrepresenting things, that can be absolutely devastating to you for your career.
Yeah.
You absolutely don't. The rules of professionalism are there for a reason. You deal with the attorneys in a different aspect than I do, and I know, unfortunately, there's too much gamesmanship that go on in appellate in litigation, and that's unfortunate. It goes with the territory. It's unfortunate. Just you have to fight it. Each of the people that are working, you have to fight it because it's your reputation, man. As I say, cases will come and go, and a year from now, you'll be into something else, and that case that caused you so much consternation earlier, it's gone. It's gone.
Well, cases come and go, but state of Florida versus JL lives forever. So let's gingerly walk our audience through this. I'm going to tee it up kind of with some bookends, but I really want to spend some time walking through this once in a lifetime experience for you. Most lawyers out there, even people who do nothing but appeals, will never get a case in front of the United States Supreme Court, let alone win, let alone unanimously. So let's give the jury a little bit of a tee up of the facts, and then you can drill deeper. JL was a case out of Miami-Dade County. It was a criminal case in the 90s where there was an anonymous tip of a black male wearing a plaid shirt having a firearm. And the police who responded saw, I think, 3 or 4 teenagers or youths. One was a black male in a plaid shirt, and they did a stop and frisk, a Terry frisk, so to speak, and they found a firearm. And as often comes up in criminal cases, the defense filed a suppression motion under the Fourth Amendment. And as I recall from the procedural history, the trial court granted suppression, but then it went up to the third district. And for the listeners who aren't in Florida it goes trial court. We have 5 intermediate appellate courts. They're called DCAs, or District Courts of Appeal. This one went up to the third, which is over Miami-Dade County. The third reversed, meaning finding with favor of the state, if I believe. Then it goes up to the Florida Supreme Court, who goes back and agrees with the trial court. Suppression was appropriate. You find yourself in Washington, D.C., arguing to Chief Justice Rehnquist at the time and his court, and you ultimately prevailed in a unanimous 9-0 opinion in 2000, written and announced by Ruth Bader Ginsburg. So can you kind of walk us back? I mean, that is a once-in-a-lifetime experience. I'm sure one you haven't forgotten. So pick any point in time in the process, but kind of walk us through how that happened.
Well, it was a surprisingly simple case. It really was. I mean, there wasn't much. It was a suppression hearing, so it wasn't very long. It was simple, and basically, you're absolutely right. What happens is that we think. I shouldn't say we think. It was the record seemed to it was argued to the court that a neighbor had seen these 3 kids, and they were in a bus shelter. I don't know if you remember bus shelters too much, but it was one of these sort of plastic.
Sure, they're
things.
littered with personal injury attorney ads.
Right, exactly. There you go. But anyway, these kids were there during school hours, and so, according to the police, we don't know because the call never recorded. According to the police, somebody had called and said there are these 3 kids out here. Here's what they look like. One of the kids is wearing a plaid-colored shirt, and underneath the shirt is a gun. 6 minutes later, 2 cops get down. It was right here on Miami Gardens Drive on 27th Avenue. 6 minutes later, 2 cops get in. One comes from the front, the other comes from the back. All right, kids, up against the shelter, and they frisk them. As you know, or certainly Jordan knows, a frisk for weapons is much more intrusive than for drugs, as an example. And sure enough, they found the gun under the plaid shirt. So that kid they kept. The others they let go, and they charged him with 3 different offenses. And you're absolutely right. The trial court, when they came for trial, a suppression motion was filed that there wasn't enough of a basis to stop these kids and to frisk them for weapons. There wasn't enough. All there really was this phone call.
Right.
But the phone call was never recorded, and the cops never got the name of the person who called. So there might not have been a phone call, or it might have been a phone call from another cop. We don't know, and I'm not making any kind of statement that cops are bad. I'm not doing that. It's just a matter of what the evidence was. You didn't know that. So, okay, so go to the third district. The trial court had granted. State takes it to third. The third reverses. But Judge Schwartz, who was chief at the time, who's since passed on, had made a sentence in his opening sentence. To my surprise, the law is that it's enough. And here's why that was. And this is what made JL so important. It was the first case in the country that had ever decided this way. Everywhere in the country, federal and state, had all said when there's a risk of a dangerous weapon, then an anonymous tip is enough. So, for example, suppose you're driving along and somebody should say, well, I see this guy weaving back and forth in his car, but they never record the call and they don't know who made the call. Is that enough of a basis to stop the car? Well, the courts are now trying to backtrack a little bit on JL, so it might be enough, depending on where you are. Anyway, reversed. Schwartz wrote what he wrote. I thought that was very interesting, to my surprise, because he was just a brilliant guy. So,
and by the way, let me just give context. I'm only interrupting for 10 seconds because I don't want to give a criminal law lecture. But back then, I mean, still now, today, but back then especially, Terry versus Ohio coming out, that being the law of the land, Alabama versus White, you're talking about reasonableness, reasonable suspicion. And back then, with I think it was Alabama versus White, was there sufficient predictive features or particularity? So that's kind of the issue here. It's not whether in a vacuum it's constitutional under the Fourth Amendment to run up to somebody based on an anonymous tip. It's what about the tip, if it's anonymous, gives you sufficient reliability to act on it. Anyway, so go ahead.
And when the state took it up, they took it up to the U.S. Supreme Court. Had it gone the other way,
the Florida Supreme Court.
I'm sorry, the Florida Supreme Court. You got a number of decisions out of the Florida Supreme Court. They were sort of split on it, but they ultimately ruled in our favor. So then that's when the state took it up to D.C. Had the Florida Supreme Court not ruled in our favor, and had I taken it up to D.C., they never would have taken the case, because it was the first one. It was the first one that really threw all the other law out there into a kilter, because they had to get some resolution to this thing. And as I was
give context to the jury. Was it, or the jury, our audience? Listen to me. Bad habits. Was this the first time, whether as petitioner or respondent, that you had a case pending review in front of the Supreme Court, or no?
Yeah, I think it was. I mean, I've since had other cases that I know Jordan, you and I worked together with Jeff DeSouza on, and there are other cases that I've taken up there, but this was the first one, I think. And actually, this was the first case out of the office that had ever gone to the U.S. Supreme Court.
Can you bring us inside that office, if you don't mind? It doesn't have to be the deliberative process per se, but what are the feelings, whether emotions, nerves, excitement? I mean,
I'll tell you the
here
truth.
you are. You now prevailed statewide.
Well, I'll tell you the truth. The office was wonderful. I was thinking about it. Had this been other places, the senior person in the office might have taken the case. Once the U.S. Supreme Court accepted it, and I only knew they accepted it because, and I was actually somewhere with my kids, and I got a call from a D.C. lawyer who was kind enough to want to take the case away from me so that I could get on with the other stuff that I had. That's how I knew the court took the case. Irrespective, the PD's office was wonderful. They really were. They let me keep the case. Beth Weitzner was the chief of the division. Andy Stanton, who was at that time a rising member of the Appellate Division. Both of them we all worked very closely, the three of us. But they didn't take the case away, and I was so thankful for that opportunity to do this. And we did the brief, and as far as the brief goes, I should tell you, this is not the only time that I've won a case where it's the first one in the country. I had at least one other case where all the law had gone against me, and I was fortunate enough to prevail on that issue. This one, it's absolutely true. In most states, federal, they had all said where it's a gun, all bets are off. And you can understand, if you will, just kind of step back for a second. What are the police supposed to do? They get a call that they get a tip, assuming that they actually got the tip.
Right.
What are they supposed to do? And I did a lot of moot courts, as you can imagine, and I had some absolutely wonderful attorneys here who would, moot me, as it were. and they asked some really great questions that made you pause. I remember Valerie Jonas, who was one of the attorneys in our division, and now she's in private practice, had said, I'm pretty sure it was Val, had said, well, what if this involved, in the middle of the afternoon, the police get a tip that there's this child, this little child, that's been kidnapped and is in the trunk of a car, parked on the street in broad daylight, and they have no way of, they don't know who owned the car. What are they supposed to do? And
did you have an answer for that?
Well, sometimes you did, sometimes you didn't. That one, well, if there's time to get a warrant, you get a warrant. I don't know the answer.
Right.
I really don't know the answer to all these things. It's been a long time since I've looked at this stuff. I remember there was another one who said, supposing that the police get a tip that it's not called the Gerstein building, which is the criminal courthouse down here. They get a tip that there's some guy who's wearing plastic explosives under his shirt, and he's on the third floor of the Justice Building, and it's on a timer, and you got a minute, and then it's going. I just thought you guys may want to know, what are the cops supposed to do?
Right.
I mean, I suppose the answer would
You know,
be,
that's interesting you got that example because, and I don't want to jump way ahead. I
no.
don't want to skip any of the boot, but during the argument before the Supreme Court of the United States, which is available, you can hear it at oia.org and other places. I think it was Justice Sandra Day O'Connor at the time, might have been another justice, who actually tossed you a similar one about a movie theater, but somebody having a bomb in there.
right.
So
I remember Justice Breyer's, the bomb question was a very interesting one. Because, and as I'm sure you guys do deal with this in your practice, you look at how far you can extend whatever the principle is that you're trying to make, how far that extends before it becomes ridiculous. Is there a limit? And I don't know if you remember from classes, Jordan, but I've often said that when you're certainly an appellate attorney, you're drawing a line in the sand, and you're saying, on this side of the line, I win. On that side of the line, I don't win. The line is made up of facts. So under this side I win, that side I don't. What happens if the line moves? How far can you take this line till you reach a point where the principle of law that you're espousing no longer applies?
Right.
The bomb situation was an interesting one because you knew that was out there. I mean, you knew it. What are the police supposed to do? And you try to be fair to everybody. You've got a position, but you also try to be fair for to the other side because you want to understand so you can make a reasoned argument. So what do you do if there's not enough time? If there's a bomb question, what do you do? And I remember the office said, well, be very careful of the slippery slope. Because if you say, well, a bomb is different because of the urgency, well, what if it's not a bomb? What if it's a guy you get a report that the guy's holding a gun on somebody? I don't know. I mean, you could think of the baby in the trunk of the car. How far can you go before you lose credibility? And the office had said, well, be very careful. I wouldn't concede anything. Don't concede anything with the bomb, because if you do, you're going to have a hard time cutting it back. Where do you draw that line then? And I actually found a bomb case, one case in the country, that was here in Lauderdale that was close. It was on the Fort Lauderdale airport. But generally speaking, I'm thinking, I don't know what I'm going to do. Hopefully I'm not going to get. Sure enough, in the oral argument, Justice Breyer said, well, what if it's a bomb? And I did exactly what they tell you not to do, which is, well, that's a very good question. And then I try to duck it, say just whatever. And then he asked it again. And I'm trying to duck it with whatever I can. And then Justice O'Connor steps in. And she said, well, you didn't answer Justice Breyer's question. Something like that, which is not what you want to have that.
yeah, big gulp.
Yeah, big gulp, absolutely. And when they wrote the opinion, Kennedy, I think he had a concurrence. It's been a while since I've looked at it. And he was saying somewhere along the line they said that it would not necessarily apply in a bomb situation. But it was a great experience for me. And it kind of helped crystallize, even in what you guys do, you're not a racehorse with blinders on. You have to be able to look at all sides of this thing. And
Now, did you moot that case in D.C. at all? I mean,
yeah,
obviously you
I'm
mooted it
glad you
locally.
brought that up. Absolutely. Georgetown Law School has an appellate clinic, and they offer for free that you can get a moot court before the argument. So Andy and I went up to the argument, and we did the moot court first, and it was horrible. They were all, the people in the court were all former clerks of the U.S. Supreme Court. These were folks who really knew their stuff. And I mean, they were just asking such difficult questions. And after the oral argument, a former law clerk for Scalia came up to me. And he got a tough job. He said, here's how you're going to win it. And you mentioned it yourself, Jordan, with the Alabama versus White case. He said, start out with that. That's your first line. This is not Alabama versus White. And that becomes your last line because that set the standard. I know we're
You
getting
said,
into the
if
weeds.
I remember, because I've listened to this oral argument 100 times, I think you told the court very early on after your name, this is Alabama versus White, but without the predictive.
Without the predictive features. But the bottom line to the whole thing is I try to be very simple about how I approach these things. You do it in your work, you have to do that. It was a great experience. And the oral argument, I thought, went very well. As a matter of fact, I finished. It was interesting. When I was in moot court in law school, and I was on the board, and I was doing my little thing, and I was so nervous, so terribly nervous. And my partner, she was cool as a cucumber, smart, just great. The night of the oral argument, I'm fine, and she's in the bathroom throwing up. Because I think, and I'm sure you all are the same way, you reach a point in your preparation where, you know what, I'm where I am, and this is the best place that I could be. I've done as much work as I could possibly do. And once you're at that point, and once you've thought it, all the things that are obstacles to you, once you've thought about that and you have answers for them before you go into it, then that's it. There's no reason to be nervous.
That's a really good point, I think, for anyone out there, not just those with good fortune to find their way before the United States Supreme Court. But I remember even way back as a certified legal intern in Florida, under certain conditions with the bar, I don't know off the top what they are, you can argue in courts, trial courts, appellate courts, what have you. And Harvey, you were kind enough, you let me do the oral argument with the Appellate Division's blessing for a juvenile appeal to the 3rd DCA, when then Chief Judge Frank Shepard was on the panel and a few others. And I walked into the law library in the court the morning of oral argument, and obviously as a student, you're letting me argue a real case. I had prepped it. There was no tomorrow. And I remember walking in and feeling nervous about the experience. I had never even been in the room before, but calm about the argument. And you look around, and sometimes there are very seasoned lawyers out there. They've got Redwells, they're thumbing through binders, they're tabbing out the record, and it made me feel like, am I doing this wrong? Should I be more nervous? And I think to your point, because you had prepared me for that, you had always said, by the time the argument comes, you know it cold, and that's just the end of it. That's not the time to prepare. But in your case, in jail in particular, you had something, it's not unique, it happens in the Supreme Court with some degree of regularity, but it's unique enough for a practitioner who's been up there. You had 2 advocates against you, so to speak, because as I recall, the court had asked an amici to come in and argue kind of in companion with the state of Florida against you. Is that right?
The Solicitor General's office. And that oftentimes happens to represent the government. And they took a much more reasoned approach than the government. Again, the issue was if the report, assuming that it happened the way the police say it happened, if the report involved a gun, then all bets are off. You just you have to deal with it right away. And I think, going to that just for a second, I remember when I argued it in the Florida Supreme Court, I said, what happens if, and I use this as a crazy analogy, I said, supposing you got these high school kids, and they're dating, this guy's dating this girl, and she breaks up with him, and he's waiting at her side of her house for nights and nights and nights because he really wants to be with her, and he sees her going on a date, and he follows them to the movie theater Actually, I think I used the Riviera movie theater by the University of Miami, and he watches them, and he gets out of his car and he sees what movie they're likely going to see, what time it is, and then he goes home and he calls the police, and he says, "There's this girl, and here's what she looks like, and she's with a guy and such. She's carrying a purse, and they went to see the 8 o'clock feature of this movie, and she's got a gun, and I don't know when, but it's sometime during the movie." She's going to pull that gun out. And she's going to. This, of course, was before the Aurora, Colorado thing.
Right.
At some time during the movie, she's going to pull the gun out and she's going to start shooting people. What do you expect the police to do? And what should they be allowed? What should be permitted to do? They don't know that this is another kid. And you know, they turn the house lights on, they pour this girl out, and they frisk her in front of everybody, up and down the legs and all that, only because of an anonymous tip. There has to be a point where that's not going to be enough.
Let me ask you, going into the oral argument before the Supreme Court, and then coming out of it, maybe that night you finally got to sleep, did you, I mean, we always love to prognosticate, even if it's amongst ourselves privately, but, I think the judge is going to rule this way or the jury will do that. How did you feel going into it, and how did you feel coming out of it? We know the actual result, but how did it feel?
Great question. I think I was probably numb going into it. I mean, you know, I'd slept. I felt confident that at least we were prepared. Andy was with me. Coming out, I actually felt very good. I really did. The position, just to go back for a second, the position that the Solicitor General had taken was the more reasoned approach. The state's position was, well, it's a gun. That's it. Theirs was a more reasoned, and I felt that could be problematic. But I remember coming out of the courtroom, when you enter into the Supreme Court, when you're going to argue, you enter through the side, through the lawyer's entrance. But coming out, you go through the front. You go at the front with all the big steps, and there at the bottom were all these people that were, and these newspapers. I remember Nita Totenberg interviewed me. There were all these people about our case. It's about our case, and there was just, and I'm listening to all the different lawyers and pontificators or whatever, talking about interviews about this case, and it was, that's when it really hit me how special.
Yeah, that kind of just gave me chills.
Oh my gosh, it was just
cool.
it was really cool, and I remember you couldn't. Obviously there were no cameras in the court, and the Supreme Court still aren't, but there were CNN, there were other. Reporters, and they had artists, and they would draw.
Did you get a
I got a nice big picture, and I got a signed opinion from Ginsburg.
That's awesome.
Sent me a signed opinion, and if you're arguing there, you get they have these quill pens, these two white pigeon quill pens, and so it framed in my wall are the two quill pens, and Ginsburg signed a copy of the decision. But it was a very cool experience. It was obviously it was something that the whole office.
Do you remember when you found out the result of it? You remember getting the call about them taking cert, but do you remember hearing or how you heard about the result?
You know, I really don't. I really don't. Now I have to sort of remember, but I really don't. I remember there were some really crazy things that happened in that case. I know that there was a Harvard law professor who we've probably all heard about, who had called me up and had said, I'd be willing to write an amicus brief for you. I said, fine, that's great. And I dealt with all of his staff. But then he wanted to argue the case. And I said, no. And he withdrew the amicus thing. I had the NRA and the ACLU on the same side. I mean, I really structured all this to make sure that I had everybody, all the bases covered.
Wow, that's interesting.
As to had it. And it was a great experience. I know that Jordan and I worked on a case that the court didn't take, but it was equally, if not more, to me, more moving. But it was
that was the Miranda issue.
Yeah.
I cherish that experience. I still think back.
That was a great case. I still don't understand why they didn't take the case.
Well, like you said earlier, were you seeking jurisdiction, or were you
in that? Yes. Now, that may be it.
That may be it.
But it was.
And we didn't have the benefit of a Florida Supreme Court
Right.
opinion, as I recall. It had ended at the district court, which may or may not factored in. But that was what an incredible experience that was.
You know, sometimes you have to be really. It's hard to think about doing it in the legal area, but you have to be sort of really creative, and something that makes you stand out. For example, I had a case, and I don't know how much time you guys have for this, and if you gave me something to drink, I could be here all day long. But
it is Cinco de Mayo, the day we're
it is
recording
Cinco
this,
de
you're
Mayo,
right.
exactly. But I remember I had this case in Key West where the cops stopped this guy who's leaning into a car talking to his girlfriend, and he drops with that. And they knew who he was. You could always hear it as you're reading the transcripts. Hear these cops get out of the police car with the jangling keys. I don't know if that's true or not, but nevertheless, and please understand, I'm not anti-police whatsoever. But with that said, the defendant, because he knew that they were going to be questioned about something, he drops a piece of paper on the ground and he runs away. They ultimately catch him. They were been looking for him for some reason. It's been a while, and they had the piece of paper analyzed and found out that it had a little cocaine on it. So they charged him with possession of cocaine or marijuana, whatever it was, and he ultimately got convicted. And I remember when we were doing the appeal that I started looking, and the law was just completely against me on this kind of thing. But I started doing research in other states and in federal, and even in Canada. I know what it was. It was a dollar bill. That's right. It was a dollar bill that he had, and he dropped on the ground and ran away. And I started doing research, and I found, especially in Canada, the Royal Canadian Police or whatever it was, that when money goes in, when it gets recirculated in the Federal Reserve, it goes on these big drums. And so if you have if you have drugs on one bill, that drug could get on the drum, and then every bill that comes after that has the potential of having drugs on there. It was really interesting. So anyway, I don't want to get into too much, but
No, I mean, look, when you have a career as storied as you do, you're going to come across a ton of fascinating issues, and I think maybe ending somewhere near where we started, which is trial lawyers out there should be encouraged to take on some appellate work, see how the sausage gets made, so to speak, on that side. And I think it'll benefit you. It benefits me, even just reading another lawyer's trial transcript. It really has a way of speaking to you in a different way instead of just being in person. So there's a lot of benefit to doing the appellate work, but I think the lesson learned here is if there are so many people out there who specialize in appellate work, Harvey's not the only one, right, and many of them are fantastic resources. And I will say, in a bit of like free advertising, I hope people don't mind, but I find that people just like Harvey, because you're not the only one, although I go to you first always, they tend to be very generous with their time. And I find it's because people who really care about appellate practice care about the law. And if they care about the law, then they care about making sure things get handled the right way. And so reach out there for resources. Look, let me just say this as we bring this thing in for a landing. I'm super grateful that you came on this podcast. It's an honor for us and for me that you were the first, non-internal guest. And it means the world to me, because I have my whole career to this point and into the future. I think about you often and your words of wisdom when I was your student. And even now, you're so generous with your time and willing to talk through an issue with me, sometimes talk me off the ledge. Now that's not a good one. And so I just want to thank you for carving the time out of your day and for everything you've ever done for me and the clients who don't even know it indirectly. Thank you very much.
Well, I just want to thank both of you two, because this is you're great lawyers. You got a great firm, wonderful reputation, and the fact that you're doing this podcast is really something to special that you do. So thank you very much, both of you, for having me on.
Yeah, no, I appreciate it. And, being the kind of the non-appellate lawyer in the mix here, with my limited experience, it's always good for me as the trial lawyer to have the insight of both of you guys. I'm very fortunate to have Jordan as my partner, as a great resource for me as well. But to have you here, I'm really happy you could join us. So,
thank you.
All right, take care, everybody. We will see you next time. Thanks for joining us.
See you
Over
guys.
and out.
Thanks for checking out the John and Jordan on Justice podcast. If you enjoyed today's content, consider leaving us a review and be sure to subscribe wherever you heard this podcast so you never miss an episode. For more information or to connect with John and Jordan, check out @OnJusticePod on Instagram and Twitter. Or check out Discord for plaintiffattorneys.com to communicate with them and like-minded plaintiff attorneys in a private Discord server. Until next time, this is the John and Jordan on Justice Podcast.